a corporation to appear to any suit by attorney are always by distress on their lands and goods. Neither can a corporation be excommunicated, for it has no soul, as is gravely observed by Sir Edward Coke, and therefore also it is not liable to be summoned into the ecclesiastical courts upon any account, for those courts act only pro salute anime, and their sentences can only be enforced by spiritual censures, a consideration which, carried to its full extent, would alone demonstrate the impropriety of these courts interfering in any temporal rights whatsoever. There are also other incidents and powers which belong to some sort of corporations and not to others. An aggregate corporation may take goods and chattels for the benefit of themselves and their successors, but a sole corporation cannot, for such movable property is liable to be lost or embezzled, and would raise a multitude of disputes between the successor and executor, which the law is careful to avoid. In ecclesiastical and eleemosynary foundations, the king or the founders may give them rules, laws, statutes, and ordinances, which they are bound to observe, but corporations merely lay, constituted for civil purposes, are subject to no particular statutes, but to the common law, and to their own by-laws, not contrary to the laws of the realm. Aggregate corporations also, that have, by their constitution, a head, as a dean, warden, master, or the like, cannot do any acts during the vacancy of the headship, except only appointing another. Neither are they then capable of receiving a grant, for such corporation is incapable without a head. But there may be a corporation aggregate constituted without a head, as the Collegiate Church of Southwell in Nottinghamshire, which consists only of prebendaries, and the governors of the Charterhouse, London, who have no president or superior, but are all of equal authority. In aggregate corporations also, the act of the major part is esteemed the act of the whole. By the civil law, this major part must have consisted of 2/3 of the whole, else no act could be performed, which perhaps may be one reason why they required 3 at least to make a corporation. But with us, any majority is sufficient to determine the act of the whole body. And whereas, notwithstanding the law stood thus, some founders of corporations had made statutes in derogation of the common law, making very frequently the unanimous assent of the society to be necessary to any corporate act, which King Henry VIII found to be a great obstruction to his projected scheme of obtaining a surrender of the lands of ecclesiastical corporations, it was therefore enacted by Statute 33 Henry VIII c. 27 that all private statutes shall be utterly void, whereby any grant or election, made by the head, with the concurrence of the major part of the body, is liable to be obstructed by any one or more, being the minority. But this statute extends not to any negative or necessary voice given by the founder to the head of any such society. We have before observed that it was incident to every corporation to have a capacity to purchase lands for themselves and successors, and this is regularly true at the common law. But they are excepted out of the statute of wills, so that no devise of lands to a corporation by will is good, except for charitable uses, by Statute 43 Elizabeth c. 4. And also by a great variety of statutes, their privilege even of purchasing from any living grantor is greatly abridged, so that now a corporation, either ecclesiastical or lay, must have a license from the king to purchase, before they can exert that capacity which is vested in them by the common law. Nor is even this in all cases sufficient. These statutes are generally called the Statutes of Mortmain, all purchases made by corporate bodies being said to be purchases in mortmain, in mortua manu, for the reason of which appellation Sir Edward Coke offers many conjectures, but there is one which seems more probable than any that he has given us, viz., that these purchases, being usually made by ecclesiastical bodies, the members of which, being professed, were reckoned dead persons in law, land, therefore, holden by them, might with great propriety be said to be held in mortua manu. I shall defer the more particular exposition of these statutes of mortmain till the next book of these commentaries, when we shall consider the nature and tenures of estates, and also the exposition of those disabling statutes of Queen Elizabeth, which restrain spiritual and eleemosynary corporations from alienating such lands as they are present in legal possession of, only mentioning them in this place for the sake of regularity, as statutable incapacities incident and relative to corporations. The general duties of all bodies politic, considered in their corporate capacity, may, like those of natural persons, be reduced to this single one, that of acting up to the end or design, whatever it be, for which they were created by their founder. 3. I proceed therefore next to inquire how these corporations may be visited. For corporations being composed of individuals, subject to human frailties, are liable, as well as private persons, to deviate from the end of their institution. And for that reason the law has provided proper persons to visit, inquire into, and correct all irregularities that arise in such corporations, either sole or aggregate, and whether ecclesiastical, civil, or eleemosynary. With regard to all ecclesiastical corporations, the ordinary is their visitor, so constituted by the canon law, and from thence derived to us. The Pope formerly, and now the King, as supreme ordinary, is the visitor of the Archbishop or Metropolitan. The Metropolitan has the charge and coercion of all his suffragan bishops, and the bishops in their several dioceses are the visitors of all deans and chapters, of all parsons and vicars, and of all other spiritual corporations. With respect to all lay corporations, the founder, his heirs, or assigns are the visitors, whether the foundation be civil or eleemosynary, for in a lay corporation the ordinary neither can nor ought to visit. I know it is generally said that civil corporations are subject to no visitation, but merely to the common law of the land, and this shall be presently explained. But first, as I have laid it down as a rule that the founder, his heirs, or assigns are the visitors of all lay corporations, let us inquire what is meant by the founder. The founder of all corporations in the strictest and original sense is the king alone, for he only can incorporate a society, and in civil incorporations, such as mayor and commonalty, etc., where there are no possessions or endowments given to the body, there is no other founder but the king. But in eleemosynary foundations, such as colleges and hospitals, where there is an endowment of lands, the law distinguishes and makes two species of foundation. The one, fundatio incipiens, or the incorporation, in which sense the king is the general founder of all colleges and hospitals. The other, fundatio perficiens, or the dotation of it, in which sense the first gift of the revenues is the foundation, and he who gives them is in law the founder. And it is in this last sense that we generally call a man the founder of a college or hospital. But here the king has his prerogative, for if the king and a private man join in endowing an eleemosynary foundation, the king alone shall be the founder of it. And in general, the king being the sole founder of all civil corporations, and the endower the proficient founder of all eleemosynary ones, the right of visitation of the former results, according to the rule laid down, to the king, and of the latter to the patron or endower. The king being thus constituted by law the visitor of all civil corporations, the law has also appointed the place, wherein he shall exercise this jurisdiction, which is the court of the king's bench, where, and where only, all misbehaviours of this kind of corporations are inquired into and redressed, and all their controversies decided. And this is what I understand to be the meaning of our lawyers, when they say that these civil corporations are liable to no visitation, that is, that the law having by immemorial usage appointed them to be visited and inspected by the king their founder, in his Majesty's Court of King's Bench, according to the rules of the common law, they ought not to be visited elsewhere, or by any other authority. And this is so strictly true, that though the king by his letters patent had subjected the College of Physicians to the visitation of 4 very respectable persons, the Lord Chancellor, the 2 Chief Justices, and the Chief Baron, though the college had accepted this charter with all possible marks of acquiescence, and had acted under it for nearly a century, yet in 1753, the authority of this provision coming in dispute, on an appeal preferred to those supposed visitors, they directed the legality of their own appointment to be argued, and, as this college was a mere civil, and not an eleemosynary foundation, they at length determined, upon several days' solemn debate, that they had no jurisdiction as visitors, and remitted the appellant, if aggrieved, to his regular remedy in his Majesty's Court of the King's Bench. As to eleemosynary corporations, by the dotation the founder and his heirs are of common right the legal visitors, to see that the property is rightly employed, which would otherwise have descended to the visitor himself. But if the founder has appointed and assigned any other person to be visitor, then his assignee so appointed is invested with all the founder's power, in exclusion of his heir. Eleemosynary corporations are chiefly hospitals or colleges in the university. These were all of them considered by the popish clergy as